You're looking live at Port Huron right now because we are going to be talking about a case in the U.S. Supreme Court right now involving two people from Port Huron. This week, the Supreme Court hearing arguments in this case about a Michigan man getting blocked on Facebook and what that really means for our free speech online. So I want to set this whole story up for you. A man named Kevin Linke lives in the Port Huron area, and he has a history of being critical of public officials. So he took to posting on the Port Huron city manager's private Facebook page, but it is public. So the city manager, James Freed, deleted Kevin's comments and eventually blocked him from his private page. Kevin sued, saying, hey, this is a free speech forum, and barring him from violating and then actually violated his First Amendment right to free speech. Now, James says the page is his, not his job's page, and it would violate his free speech if he couldn't block Kevin. Are you following this so far? All right, this happened back in 2020. It has made its way all the way to the Supreme Court. With me now is Jen Dukarski. She's an attorney with Butzel who specializes in media and technology. Jen, thanks so much for joining me. It's good to see you.
Likewise, great to be here.
So tell me, is this the first of its kind case that really tests Facebook blocking and free speech?
It's the first one that's really going to get that far. There was a case not too many years ago that questioned whether Donald Trump's account, his @Real Donald Trump, was actually a government account. But after he lost the election, the Supreme Court decided that was moot. And this issue has just been hanging around since then.
This is interesting because when we look at Kevin Freed, he won his case at the Sixth Circuit, saying that he wasn't operating this page in his official capacity. But then when you looked at a case that the Ninth Circuit took up in California, saying that public people have their jobs and intertwines their personal and their jobs on their personal page, that's fair game. So how is the Supreme Court going to balance this?
It's really challenging. In 2017, the Supreme Court, in another case in North Carolina, decided that really social media is today's modern version of a public forum, a public square. Now you have a situation where people are using their pages both to post those cat pictures and to post information regarding their position in office, whether it's to share information, to collect and gather facts. There was a recent study that showed that 75% of people in the United States Congress found that this was a great way to communicate with their constituents, and 71% actually were influenced by their comments when they didn't have an opinion on an issue. So it's becoming more and more popular. It's more and more a public forum, a public square, so to speak, and it puts a balance in where the Supreme Court is trying to decide how much can I restrict someone's speech when you have diversity of viewpoints and when you have something that's semi-public and semi-private.
It's interesting because, again, if that is the only place where a constituent can feel that they can get information from a public official or can get that feedback or interaction, then it would seem to be fair game.
Well, it's a lot like going to an open meeting. You would expect that in an open meeting, you'd be able to share those public views that may be unpopular or may be divisive to some degree. There, you really don't have the opportunity to stop someone's free speech, but yet you can hide comments or you can put somebody, you can turn them off of your public page and ban them from following you. It really makes a complex situation, especially when you do have a balance of things that you're sharing that really is private and family related, but yet you're sharing information with the public. And that's what the Supreme Court is really wrestling with. Where do you make that dividing line?
All right, so when I think of all of us and all of the personal pages that we have, and I think even sometimes my blurring of the line of, doing things and putting out some of my work on there, and then, as you said, the aforementioned cat pictures, what will this mean for all of us when we watch this really carefully?
I think we need to keep an eye on where this falls, because I don't think a rule where if you post one more cat picture, you now are a private account versus a public account is a dividing line that's going to work. I think we need to look to transparency when someone is elected to office, however, and really keep this in our eyes, watch for how the Supreme Court balances the interest of the public in being able to communicate with their represented government.
All right, so we know that things don't move quickly at the U.S. Supreme Court. When should we expect to hear something on this?
I would say it's getting cold enough. Get yourself a hot cocoa. It's going to be probably next summer.
All right. Thanks so much, Jen Joukowsky, for joining me. I really appreciate your perspective on this one. We're going to check back in with you. We appreciate it.